everyone, we the students of Amity Law School, Kolkata have brought to you our first legal awareness drive on the topic the basics of legal awareness that everyone should be aware of. Now, literacy has always been associated with the ability to read, write, use arithmetic. But now, recently, in the current situations, the meaning of this term has expanded to include the ability to use the language, numbers, images, computers, and other basic means to understand, communicate, and gain useful knowledge. Amongst this, legal awareness, sometimes called public legal education, is the empowerment of individuals regarding various legal issues, hence promoting consciousness of legal culture and hence enabling them to be a part of the process involving the formation of law and the concept of rule of law. Legal awareness is enabling people to demand justice, reliability, and remedies at every level in their existence. It enables to understand and anticipate legal troubles and take the required and necessary steps in order to prevent their occurrence. When a person is aware of his rights as well as his duties and has a brief legal knowledge about them, they can easily approach a lawyer for consultation and advice in time, hence confronting or averting the crisis as it easily approaches a lawyer. It is known a fact that ignorance of legal knowledge magnifies the impact of legal troubles and difficulties when they take place. Now, the society at large believes that it is the law students or the lawyers who should attain legal knowledge without even realizing how important it is to understand the primary legal education. It is important and essential that the society should at least have the basic idea of laws, that is, from fundamental rights to laws relating to consumer protection and so on and so forth. Now, people think that this is not their cup of tea, therefore, never putting an attempt to gain legal knowledge in whatsoever way possible. Therefore, when an individual right is violated in many instances, it is not because primarily due to lack of knowledge. Why basic legal knowledge is necessary? There are specific questions that are always left unanswered, like what would one do if someone stops them from entering a public place? What would one do if someone denies them an opportunity without any valid reason? Maybe a person is aware that yes, his right is infringed and he can approach the court. But the question is here is which right is infringed? How to enforce it? This gives a scope to the people infringing it, which should not be the case. Many people are not even aware of their fundamental rights as provided by the Constitution. So, the primary reason that they are not even aware is making it essential to know the laws as it allows a person to protect himself or herself and also making sure that they are acting lawfully. Similarly, when one does a business, a basic knowledge of contracts and agreements will make it easier. Knowledge of laws, in the same way, will enhance the quality of life and reduce the tax burden also by providing legal codes, mentioning procedures for seeking statutory deductions, etc. Now, there are some basic legal rights and laws that we as citizens of India should always be aware of, like the Motor Vehicles Act 1988 that states that a person can be arrested without a warrant when and if found drunk more than 100 ml of alcohol in their blood content, or the CRPC, the Code of Criminal Procedure, which mentions that no one should be arrested before 6 a.m. and after 6 p.m. except by taking necessary permissions, or a police officer cannot refuse to lodge an FIR, or the Maternity Benefit Act 1961, which states that no company can fire a pregnant woman. If a person is penalized for a crime like riding without a helmet or any other reason, these are day-to-day crimes that we come across every day. Yet the people of our country at large choose to remain majorly unaware of these laws. So when these laws are coming into play, then crimes like this, suppose riding without a helmet, then they cannot be penalized for the same reason on the same day more than once. These laws are essential to be understood into the basic level of people's understanding of the law because it helps them to achieve a better status of living in their daily lives. Depending on the goals, there can be a number of objectives for legal literacy programs, from raising awareness to building capacity, training of trainers, community education, legal empowerment, exposing law students like us to social justice work to spread legal awareness, and strengthening the community solidarity and supporting grassroots advocacy. The importance of legal literacy is manifold, yet it can be jotted down into a couple of points. Like legal literacy is that where one needs to have some broad information about legal provisions and processes, and it is the elementary knowledge of law and not an expert knowledge of an advocate. So that becomes the most important aspect because always people confuse that only the law practitioners or law students or advocates in general should have legal knowledge, but these knowledge of legal rights that one is entitled to and the legal duties that one owes to others, everyone should be aware of. Legal literacy makes us aware of several laws which have been enacted for the welfare protection and security of the citizens. Absence of legal literacy leads to the perpetuity of exploitation and victimization in many fields. It makes us responsible persons of a civil society and a society which is not just and orderly, but one where everyone lives with honor and dignity, which is the most important part of a developing country like ours. Legal literacy helps to promote legal consciousness. And in this aspect, I would like to highlight two important case laws. In Union of India and others versus Shanti Yadav and others, it was held that to support legal literacy, including legal counseling, legal aid and analysis and evaluation of existing laws becomes of prime importance. Also, in Sri Bajrang Vidyalayan Samiti versus the state of Rajasthan, it was said that the state is duty bound to ensure that certain standard of education is maintained throughout the state. According to the Bar Council of India Act, one of the duties imposed upon the Bar Council of India is to ensure that legal education is imparted while keeping certain standards in mind. Now, the major question is how can a person abide by law without knowing it? There is a major hindrance to the successful implementation of any law for that matter. A large number of cases of violation are due to no legal literacy. We have an article in our constitution, the Article 39A, which gives a directive to the states to ensure that the operation of the legal system does not promote justice on a basis of equal opportunity. It directs the state to provide free legal aid with the aid of suitable and sustainable legislation or schemes. The Supreme Court of India plays a very crucial role in this aspect in delivering certain judgments which create awareness among citizens about their rights and spheres of national life. Along with the constitutional provisions of India, the media also plays a useful role in making people aware of their legal rights and simultaneously contributes to increase in their legal literacy. Also, the judiciary drafts laws to enhance legal literacy by simplifying the language of the law. That is an obvious responsibility of legislature and that of judicial pronouncements. Now, if we look into the government initiatives to help legal literacy and to help the spread of legal awareness, there has been a couple of recommendations and implementations, including the National Legal Literacy Mission, which empowers the citizens and fosters an open society based on the foundations of political awareness, social equality, and economic empowerment. The objectives of this mission is to promote awareness, redress social and economic imbalances, ensure land rights, provide legal aid to the ladies, promoting social consciousness with respect to gender equality, social justice, along with environmental protection and human security and other similar noble objectives. This is a very comprehensive mission that was undertaken by the government, which has proven to be very, very successful. Also, our our ex-Chief Justice Ranjan Gogoi also said that the National Legal Services Authority or the NALSA and the State Legal Services Authority are the crucial vehicles for discharging the constitutional mandate of justice to all on the basis of equal opportunities. These bodies have ensured that through their methods, justice reaches the remotest corners of our country and it is available to each and every person. Now, to better understand how these laws affect the daily lives of people at large, we have conducted a survey of approximately 50 people in residing in the area of Salt Lake, that where we reside in, And the population of the survey extends from daily wage earners, laborers, tailors, and maid servants to school students, college goers, all the way up to qualified chartered accountants. Because the purpose of the survey was not only to enhance the legal knowledge or spread legal awareness amongst the people that have zero to very negligible legal knowledge, but also to clear some doubts and misconceptions amongst the minds of the people that consider themselves to be legally aware of their laws. Now, if we look into some of the questions that were asked into the survey, we will find that these are very, very basic questions. Like, for example, what happens when a person is arrested without any reason? Are there any legal remedies that the person can exercise? So the question was asked, and the options were given yes, no, or they have to consult a lawyer, or they should be given a compensation. Surprisingly, the majority of people replied with no, that they cannot get any legal backup or they cannot get any legal remedy if they are arrested without any reason. Whereas the law actually states that according to section 339 of the IPC, which mentions about wrongful restraint, one person cannot be arrested wrongfully. And in regard to this as well, section 21 and 22, article 21 and 22 of the constitution can be invoked for the same. Now, if we come to another important question, like that happens, that will range into any case and every case that is filed in the courts. That is, what is the limitation period for filing a civil court for filing a civil case or criminal case? Then also, people were mostly unaware of it, whereas uh, the limitation period ranges from 3 years for a civil case to 6 months for a criminal case. So moving on to another important question is that how many people are aware of the steps or actions that they should take if their check gets bounced. This happens on a more general basis than we can ever imagine, because it's the problem that most people face on their day-to-day lives. But the sad part is people don't really know about the legal remedy that is available to them, and they get misled by some judicial interpreters, and just because of the fact that they are not legally aware. Now they have a legal remedy available to them if their check gets bounced. For example, if Mr. A is supposed to get a check, supposed to receive a check from Mr. B, and that check gets bounced, then he is legally bound to retrieve that check from him within 30 days. Or if not, then there is a legal provision for the same, which states that according to section 138 of the Negotiable Instruments Act, if that check is not retrieved back within that stipulated amount of time, then a criminal case can be lodged against that person. Coming to the next question, it's a very important one in the present day scenario owing to the number of harassment and cases that are happening against women. And also, a lot of people are overshadowing the fact that there are a lot of women offenders as well. So, a basic question would be like, during what time can women not be arrested? And the options were given that they cannot be arrested at any time after the sunset, or any time before the sunset, anytime after 9 p.m., or between 6 to 9 p.m. Now, a lot of people said that they cannot be arrested between 6 to 9 p.m. That is the majority of the evening part of the day. But whereas the law states that they have to be arrested before sunset under all circumstances, apart from special circumstances, if the crime is that heinous and grievous in nature, then they can be arrested on spot. Lastly, if we come to the one last important question, it would be that if there is a crime committed, a sexual offense is committed against a woman at his or her at her workplace, then within what period of time should she file a case against it, or should she apply for a legal remedy? And the options that were given was ranging from 1 to 3 days, 7 months, no time limit, and within 3 months. Now, this is one thing that most of the people answered correctly, that yes, Within 3 months, it is the time limit within which that it's the period within which the woman has to apply for a case when a sexual offense has been committed against her at her workplace. Now, to further clarify the doubts that are hereafter mentioned or hereafter can be found in the minds of our viewers, we have kept a special consultation and interview with a panel of specialists ranging from an inspector in charge of the Electronics Complex Police Station in Salt Lake to Mr. Arnob Dotto, an advocate on record of the Calcutta High Court, as well as Shudipto Moitra, a retired advocate of the Calcutta High Court as well, who will further delve into these questions and clarify any of the remaining doubts that might hereforth be arising in the minds of our viewers.
So the first question is, can women file an FIR whenever they want?
Yes, women can file FIR anywhere throughout India. The point of jurisdiction will not be the bar of complaining for the women in a police station.
So next question is, if someone is wrongfully arrested, then what are the legal remedies available to him or her?
In respect of illegal arrest, anyone who has been illegally arrested can take the government aid of advocates or from the judicial forum. He can apply and he can take the remedy protesting the illegal arrest of a person, individual person.
So next question is that what is the difference between a GD and an FIR?
GD, generally GD laws in a non-cog information, and in respect of FIR, cognizable offencer made in FIR.
So the next question is that when can we arrest a woman?
When can we arrest women? Women can be arrested cannot be arrested after sunset, before sunrise. But in a rare case or in a heinous crime, this bar may not be maintained.
Hello, this is Arnab Datta, Advocate, High Court, and as per question asked by Rohini Das, I am hereby giving the answer. For question under serial number 1, the answer is for loss of any stolen valuable belongings like cell phone, jewelry. What are the legal remedies? The remedies lying under the law is that the person whose article was lost has to lodge a police complaint police complaint with all the details of the article, like for jewelry, he has to attach the bill of the jewelry, which contains the date of purchase and bill number, everything. And for cell phone, the person has to block the SIM, and for that he has to in this complaint he has to mention the SIM number and, if possible, the INEI number of the equipment, which is written in the box of the equipment. Now, for loss of any, in question number 2, for loss of any identity card like Aadhaar card, voter card, passport, etc., again the person has to approach the police authority and has to lodge a complaint with all the detail of the documents, like document number, date of issue, if possible, and thereafter, after and possible, and a tentative place from where the document was lost, if that was available at all. And then after the lodging the police complaint, the person has to approach the competent authority, competent issuing authority of the documents, and has to apply for a new card. In case of Aadhaar card, voter card, and passport, the person has to approach the competent authority and the competent authority, on the basis of the form, will issue a new document of the same serial number. Now, in case of in question number 4, that is, in case you are wrongfully arrested without committing any crime, public offences, that what legal right can you exercise? In this case, if a person has been wrongfully arrested by the police authority, then he can move before his family member can move before the High Court and under Article 226 and ask for in the writ under no. And has to file a writ petition under Article 226 of the Constitution in the nature of habeas corpus, which means a direction from the court upon the police authority to bring the person before the court of law. Now, in case of question number 4, suppose you are facing which deals with consumer apathy in case of selling where the seller or the company has refused to take the defective goods. In that case, the consumer can should have to approach the consumer forum under section 12 of the Consumer Protection Act. In this case, if the value of the good is below 10 lakh, then he has to move to the district forum, and if the value of the good is above 10 lakh, then he has to move to the state forum. Thank you.
Within what period of time is it important to file against sexual harassment experienced by women?
In my opinion, or as law provides, a person who faces sexual harassment should promptly go before the authority seeking redress. Because under the law, the delay dilute the causal action. And unless a prompt action is taken, it may arise at the appropriate stage that it may be afterthought. So, an immediate action is important because for sexual harassment, the victim ought to be examined medically. If there is delay, then evidence could be erased out, and by medical evidence, by medical examination, the proof or the evidence of sexual harassment may not be available. So it should be at most prompt and quick as possible. But there are some occasions when when the victim is severely abused or harassed by sexual harassment, and it was not possible for her to go before the authority seeking redress, then that will be an explanation for lodging the complaint before the authority belated. But usually it should be very prompt and immediate action ought to be taken.
Thank you, sir. So the next question is that if someone is wrongfully arrested, then what are the legal remedies he or she can exercise?
She has various legal remedies which a person wrongfully restrained or detained could be availed of. Firstly, arrest is the investigational procedure. Under the Code of Criminal Procedure, police can arrest a person on suspicion under Section 41 of the Code of Criminal Procedure. But it is a constitutional mandate a person arrested should be informed of his reason or grounds for arrest, and if there is he is suspected to be involved in any cognizable offence, then he should be produced before the nearest magistrate within 24 hours. If not, the arrest will be bundled. And Article 21 of the Constitution of India mandates no person shall be deprived of his right of liberty except in accordance with law. So law provides the person arrested should be informed of the ground of arrest and can be arrested on two occasions. If he is involved in a cognizable offence, and what is cognizable offence, that is defined under the Code of Criminal Procedure, or if there is a strong suspicion that his arrest or detention is necessary so that any further violence, to prevent the further violence at the local, then and then only person could be arrested. But he should be produced if he is arrested in connection with a cognizable offence before the magistrate within 48 hours.
Thank you, sir. So the next question is that generally we know that women can use Section 498A for domestic violence. Apart from that, if a woman suffers any sort of violence, whether domestic or anything, what are the sections or legal remedies she can exercise?
Yes, there are ample of sections. Firstly, if a woman is ravished, then 498 has got more manner of application. She has to take recourse under Section Indian Penal Code, that is C76. Or if there is any offence regarding matrimonial, suppose the husband of a woman contracted a second marriage during the lifetime of the first marriage, he can take recourse under Section Indian Penal Code. It is not under the Domestic Violence Act or under 498A itself, a section within the Indian Penal Code. There is another statute that is called Prevention of Domestic Violence Act. That's a separate aspect. There, a person, lady can seek the right, has right of residence, right of maintenance, etc., etc. But 498A is an offence against is an offence under the Indian Penal Code for causing cruelty upon the wife by the husband or his relatives. So it is within the Indian Penal Code along with the other sections for which the provisions have been made for redress of the women's suffered in your.
Thank you, sir. So the next question is it important to do a legal search when a lame person goes and buys an immovable property?
Follow? I couldn't follow.
So the question is it important to do a legal search if a person decides to purchase an immovable property, such as a flat or a
Yes, yes, yes.
house?
Of course, search. Search means what? Search means in order to ascertain whether the property intended to be purchased has already been sold away or not, or search from different from before different authorities. Firstly, search before the settlement office in order to see, in order to ascertain whether the property stands in the name of the vendor. Or again, search ought to be made. Nowadays, Information Technology Act is very much in force. He can ask under the IT Act before the banking authority whether the property has been mortgaged in bank or not. This is another kind of search. Another search is with regard to the conversation of the property. If the property is situated on a land and that land was a marshy land, then unless it is converted to the homestead land, the construction is not permissible under the law. So these are very, very important in order to purchase an immovable property for for the safety of the vendor, safety and security of the vendor.
Thank you, sir. So I just have two more questions. So the next question is, when can a woman be arrested?
Very big question. Arrest why there will be classification of women. If any person could be arrested under certain circumstances, whether it be woman or man, immaterial, a woman and a person could be arrested if he commits any cognizable offense. That is, it can be possible by women also, as also the men. So there cannot be any distinction when a woman can be arrested, when a man can be arrested. All are at par under the law. Procedure may be otherwise, because for arresting a lady police is very much necessary.
So the first question is, how many people think there is a limitation period for filing every civil and criminal matter?
This question, in my opinion, has got no relevance because general people are not aware of the law. Question of filing the petition within the period of limitation is a question of law. So unless a person is accustomed with the law, how it is possible for any person to know what is the period of limitation for filing any application into the court, either in civil jurisdiction or in criminal jurisdiction or under the constitutional law. In every branch of law, in order to initiate a proceeding, there is a procedure. Law of limitation is also a law of procedure. So a person, unless or very much accustomed or familiar with the provisions of and limitation is governed by the statute, that is called Limitation Act. So unless a person goes through the Limitation Act, how it is possible for him to ascertain the period of limitation in filing any application? So this question, in my humble opinion, is not relevant at all because people are not supposed to know the law of limitation. So whenever a person intends to initiate any proceeding, it is his duty to go to a lawyer, and that lawyer will advise him whether his cause of action for which he intends or he seeks any demands comes within the period of limitation as prescribed under the law.
Thank you, sir. So the next question is, within what period of time is it important to file against sexual harassment experience by women especially?
This question is very important because in our country, mainly the women folk, when face the harassment for sex.
I hope those statements by our qualified dignitaries have helped you to get some clarifications regarding the doubts that might have arisen in your minds while watching through the video. And I sincerely hope that after watching this video, you are one step ahead than all those who are unaware of these laws that they are basically subjected to in their day to day lives. I would like to take this opportunity to extend my gratitude to all those respected dignitaries that were present here amongst us. Thank you, sirs, for helping us with your legal drive. We are forever grateful. And thank you all for taking your time out to watch this video today. I hope you have learned something from this and hope to see you soon again. Thank you.